Ladies and gentlemen, at this stage of the case, the lawyers will be making their final arguments to you. In making these final arguments, the attorneys will be commenting upon the testimony you have heard and the evidence that has been presented in this case. Like you, they will be recalling the evidence in the case. They will not intentionally try to mislead you. If their recollection of the evidence differs from what your recollection is, you must follow your own recollection. These final arguments by the lawyers are not to be interpreted as evidence by you in this case or instructions on the law. Nevertheless, these arguments are intended to help you properly understand the contentions of each side, and you should give them your attention. Each counsel will have, 20 minutes? Is that what we said?
I thought we said 15.
15. Okay, each counsel has 15 minutes. All right.
Your Honor, I'll reserve 5.
Yes, you may proceed, sir.
Thank you, Your Honor. May it please the Court.
Rich.
Mr. Bolanos, ladies and gentlemen, so we're here now 24 hours later to talk to you. We had mentioned it before I did, and asked you to make a decision about who is the lead, and you're going to have to get back and talk about that issue. The court is honored to give you some instructions that are going to be read to you to get back on the law. The reason I'm bringing it up is because one instruction is about a contract. You don't need a right to a contract. You don't know what a contract is. You also need instruction about my clients or the defendant. Those instructions are helpful. They will guide you in the law. You are going to decide the facts, however, and then one question you get, or one instruction you get is, what's the standard to be reviewed? Taking all this down, you can all in. And it's which side has the burden. Can't have the burden. It means the burden proof. And the burden is by preponderance of evidence. It means tipping the scale, if you're looking at it that way. Whichever tips it or an even balance, that's enough. Now, there's a reason for that. It's because jurors are always asked to make tough calls. And they have to look at the facts. So there's some direction given to you by the court. I'm not going to recite the evidence. Typically we do that as attorneys. I will point out some, but I'm more really going to focus on what I think is what you have to talk about when we're all finished and you walk out for the last time before you make your final decision. And that is, was there this agreement? Andy, James, Tim Walczak say there was. Tom O'Connor says there wasn't. So starting from that proposition, when you come back here, you're going to have to decide that question. So let's look at the facts. Not from the perspective of what you already know. You've been very, very attentive. What you didn't know is while you were watching the witnesses, watching the other attorney, I was watching you, and I'm very happy with what you've done as yours. So what is it that I'd like you to take back to the jury with you? The defense by Mr. O'Connor has stated and verbalized initially, that makes sense from his perspective. I didn't have to agree. But when you peel back what he said, and when you confront him what he said before, it doesn't make sense. And I like to consider that when we go back into the room. He says that he wanted a fair price. First thing is, not a fair price. And every chance that you repeat, that's fine. But when I confronted him with his sworn testimony in 2009, and I read it. He said, when I asked him the question, and you recall Mr. James saying, I'll offer these to you, and in response saying, I'll pay what you paid for them as a fair price, that's fair, I'll pay what you paid for them. Answer, I'll pay a fair price in this case. In this case, this truckload, yes. I would pay almost full retail for this, in these cases on the ship. And I asked, how about full wholesale? Do you recall saying that? Answer, full wholesale, yes. I think he meant wholesale at the time. So he says something, but then when you confront him on what he said, his memory may have been better, or he wasn't coming before a jury, he said something really that didn't fall in line with what he was telling me. He volunteered it. He never gives stuff away. Now, why am I saying this? Mr. Chris, why are you even saying that? Because I pointed out to him that section of the transcript of his testimony. He gives stuff away all the time. I don't know why he said it here. I think Tom, as he likes to be called, is a salesman. He doesn't believe that he should owe anything. He's going to talk it and talk it and talk it until he convinces her, that he has agreement. What else doesn't make sense? He said the reputation was good. He didn't say it was good. It was very, very good. And he was considered a very honorable man. But yet, he really is telling you indirectly. You go back in the room and say, don't believe it. Now, it could be a misunderstanding. That's not what he's saying. That's not about misunderstanding. He's telling you that this man is not telling the truth. I mean, it's said in a nice way, but Mr. James, Andy said I delivered the product. I delivered in boxes. It was good stuff. We talked about it. He never complained. Today, you heard from Mr. O'Connor complain. Now, have you stayed? Sure. But what doesn't make sense is, think of this. Look at this. Today, Mr. O'Connor says that absolutely this was not a good product. I would have done something and I was upset about it. But then he keeps paying. He pays $5,000 the next year, another $5,000. And they were fair with me, charging interest. They just said, pay when you can. But you got to pay. That was the deal. Fair market value, what you can sell it for, but a fair value based on retail, and that's what they said. Was a wholesale price. The other thing that, again, these are little things, but I'm pointing them out because I think sometimes little things are telling in a jury trial. Mr. O'Connor got up in front of you and, of course, said, James never delivered any product to me. And this, of course, before he knew I was going to cross-examine him on the word bunker. But he said, here, before I said anything, told you that it never happened, couldn't happen, he didn't bring anything, but $11,000. It happened, Tim Walczak, he brought the stuff. He said that, and this is what I asked you, the question. All right, tell me, in any other context with Mr. James after that call where he offered, you said he offered some money. I need to have to fire him. Answer, no. Prior to opening up and after my building was completed, Andy called me and said he had some product in his bunker and he wanted the product out of his bunker. Would I be interested in the product? I said, sure, I'm interested. How am I offering that is, I think that supports Mr. James' version. He delivered that. That's $11,145. It was a long time ago. I'm not faulting Mr. O'Connor for not remembering it. And he's feisty. He wants to fight. He doesn't want to pay anything. You understand that. This has been going on a long time here. And it just doesn't make sense that when I asked him about the bunker, that you want to talk. I don't know anything about bunkers. Huh? I didn't bring up bunkers when I asked it to you in 2009. You brought up bunkers. The only time bunkers came from something was in 2002. So Again, Mr. Kuss, what's the point? The point is, that falls in the line of what Andy James is talking about, not what Mr. O'Connor is recollecting. He says that he can't remember Andy delivering, and of course you saw Exhibit E and F, $11,145. That's what I did, that one inventory. He can't remember that. But he doesn't object to the $11,145. He doesn't, if you even take it, he says, I didn't get anything until 2 years later, in the fall of November of 2005. 2 years later. He doesn't point out after he gets it, hey, this isn't right. I don't know what you're talking about, $11,145. Why do I say that? Because of this. This case, the defense in this case, has been set up to show that Mr. O'Connor has been around a long time. These are naive businessmen who've only been 2 years in that business. He's an expert in retail. He did an I reject product like that. The second Vince takes him. He doesn't do anything to reject it. He's there when it's unloaded. But here it comes 2 years later, when he's presented with the bill. He doesn't say it was a bad product. He doesn't say it was a distressed product. Yeah, he says today, I brought him in. I brought him in and told him that within several weeks or several months, I brought him in and told him, well, this stuff, a lot of this is not a choice product. But that wasn't the deal. The deal was take it wholesale. Take it wholesale. Finally, it doesn't make sense if someone is so adamant about not paying, why they would continue to pay. They had this meeting in November of 2005, and he says, I want to pay $25,000 to end it all. And he writes a check and he's got $5,000. Why? Why would you do that? Now think of that. Discuss this. Because Mr. O'Connor is a very sympathetic person. I'm not here. This isn't what this is about. People come to this courtroom to settle their differences in a way where evidence is presented orderly, without acrimony. But we can't have a situation where people just can get up and say anything without being accountable. So the question is, if you didn't like it, if you thought it was bad, why did you continue to pay for it? And that's the concern I'm pointing out to you. Of 5 things that it looks like, certainly, there's question about Mr. O'Connor's recollection. So I think there were 2 deliveries. It's obvious that Mr. James testified to that. Obviously, Mr. Walczak testified. They're both combined. That was a dollar amount. Now, Mr. O'Connor professes to be shocked about the $49,000. And he could have bought more. Then the question is, he's the guy that's been around forever. He's the guy that knows the business. And he doesn't drive 2 blocks down or 3 blocks down and walk in the store. He says, oh, I never go to my competitors. Well, okay, I'll give him that. He doesn't go to his competitors. But this isn't competition. This is after they talk. And now Mr. O'Connor's agreed verbally that, well, I'll pay wholesale, fair price wholesale, what you paid for it. And he doesn't go there to check it out. And he never says anything. He doesn't say anything after it's delivered. He doesn't say anything before the $5,000, first $5,000 payment. He doesn't say anything. Second $5,000, doesn't say anything when the $50,000. Why? I think this is why. I think Mr. O'Connor, like all of us, suffered from buyer's remorse. And I understand that. It's human nature. He kind of took it. Apparently this was a big thing that he took a lot of stock from a doctor and was able to parlay that into to sell it. In his mind, he thought that was a distressed sale. This wasn't a distressed sale. They testified. Business was okay. It's hard, but they were looking, they were looking at the display work. But they weren't getting out of it until Mr. O'Connor said that. Now, Mr. O'Connor says just the opposite. Okay? Talk about that. Talk about if Mr. James would be here. What has impugned his recollection of the testimony? You look at the documents, the E&F, and either the white book or the black book of the plaintiffs, those show the different numbers It was explaining how those numbers were created. It took them off their sales figures that their wholesaler gave to them. So, review those. There is some difference in the figures. Remember, they were charged freight, so they computed that in there. But again, no complaints about any of this. I mean, you would think that the moment everything got here, according to Mr. Hunter, that he was just going to pitch everything. Now, Mr. Krupinski, I recall, said that everything was sold, and what was left in the box was what was not sold after a certain amount of time. Mr. Hunter says something different. He said that he took it in the back, and he'd bring it back and forth each season, and they finally ended up giving it away. But he didn't give product away. That was the deal he made. He got a lot of product. He got either 1 or 2 or 4 or 5 days worth of hauling. I think it was, according to Mr. Walczak, Tim said, probably 2 days. So, what does that leave us with? It's not an easy decision. It's one that I think you probably knew was coming. You have to decide who to believe here. Mr. James, Mr. Walczak presented in 2 different loads about $49,000 worth of product. He got paid a little less than half of that. Now, the point I was trying to make in the examination of Mr. O'Connor was, why would you, if you were really adamant that you're a pretty good businessman, you'll pay more than 50 cents on the dollar for box goods, and a lot less than that for the shelf stuff that comes in separately, why would you be sitting in a restaurant in Maryville 2 years later offering another $15,000 after the 10? That's well over the 50% mark. That's well over it. If you discount, and he said a lot, he didn't say how much, but if you discount boxes, and he said about the testimony is different, I think 70% was said to be in parts and 30% in boxes. So if you discount the 30%, and say, okay, we're going to take half of that, and then the rest you have to discount even more. He's paying way too much when he offers them at the Miracle restaurant. So why? Well, like he said, he wanted out. But not because he wanted out because it's unfair. It's what he's done. And here's I think the psychological part of this, I don't know, these people trusted each other, they had an agreement. Mr. O'Connor doesn't want to pay the remaining amount. He's not provided any evidence that Mr. James was dishonest, that he was ready to get out of the business. He was definitely ready to get out of business once they offered. But he hasn't provided evidence that what Mr. James said, that he said he was going to pay more, pay us back. Tried to, but his previous testimony he said, I'll pay wholesale. When I was younger attorney, we don't have kids and we don't have money. I can remember buying what was offered back then, I don't know if they still do it, but 0 down, 0 interest for a year or 9 months type of products. And had 3 little ones, and then the 4th came along, it was the boy. So there weren't one boy furnishings. So I came in and said, okay, let's do this, and we can defer paying for a good year. I can tell you, a year later, after the boy had mangled that furniture and beat it up, and I owed full price on it, I didn't feel like paying that. It was wrong, but I didn't feel that. I thought, well, okay, it's a deal, I got to, but man, I sure didn't want to pay that. So what's what happened here? It was a great deal. He sniffed it. He knew. He knows what's going on. He's been all around. And he knew once he gave him the tip, the push him into getting out, so he's going to pick this up. He said it. He agreed. He didn't mean it. Maybe he didn't mean it. That's not what he said. He said you pay wholesale. That's what he said. He is believable. You're going to need to make those decisions. You're going to get an instruction. The instruction is on your teachings. When someone is confronted with prior inconsistency...
Counsel,
Yes, sir.
you're going way over your
Oh, I'm
time.
sorry. I thought, okay. I'm sorry. Thank you, ladies and gentlemen.
Judge, Mr. O'Connor, Mr. Andrews, Mr. James, Mr. Walczak, and Mr. Price. Good afternoon. We're at the end. Okay. This is really a simple case, but it's an important case and it's a big case for these two gentlemen and for that gentleman over there. This is a business transaction between businessmen, where the essential component is the price. You have two seasoned businessmen over here, and you have a seasoned businessman over there, and they didn't discuss price. What is a contract? A contract is an offer, acceptance, and then consideration. You give an instruction on it. That's the element. How do you make a cake? Put the cake mix in, you put the eggs, you put the water, you mix it, you have a cake. Okay? That's what a contract is. Use jury to find out whether or not there was a contract and whether that contract was breached. And if the essential component here is the price, and that was never agreed upon, how can you breach a contract? What we have here is we had two gentlemen that are in the business 2 years. They've admitted that Planted Fireworks was in the business in 2002 and 2003, and we do not know the retail aspects of it. You know what's really nice about this case? They never said anything bad about Tom O'Connor. You know what's nice about this side of the case? We never said anything bad about Mr. James and Mr. Walczak. Now, one person came in here and said, he's a liar. You didn't hear that. You didn't hear mud. You didn't hear dirt. There was nothing thrown against the walls hoping something would stick. What did you hear consistently from both sides? We didn't agree on the price. We didn't have a written contract. Okay? Now, one side wants you to understand that that price was discussed after the fact. Okay, they want you to figure out that, okay, in 2003, after everything was delivered, that's when the paperwork was generated. Mr. O'Connor says, that paper wasn't given to me until we got it in Don Pablo's 2 years later. And if I knew that I was going to spend $50,000, $49,316 is what the exact number is, for a product in a store that's been through 2 seasons, and it's product that didn't sell to the consumer, I'm not buying top choice product. I'm buying what's not been sold. Okay? Are you going to pay top dollar to buy product after the selling season? That means this is what the consumers do not want. And Tom O'Connor will tell you, I had purchased that product. I knew I was buying distressed product. I knew that I was buying product that people were not going to get. It's not the choice stuff. I was looking for the cakes. Those are the things that have a ton of stuff that pops out when you light one fuse. That's the good stuff. That's the prime choice stuff. Why would he buy $15,000 of distressed product when if you look at all the exhibits that were given to you at the end, I believe they were 23 through 29, you'll see what his cost of goods were. A big deal was made because one year he paid $25,000, but if you look at subsequent years, they were about $60,000, $70,000. And he's buying choice product from vendors, brand new, still in the box. Now, there's a little mud. I don't want to use the word mud because they didn't slanderize each other. But you heard that Mr. O'Connor said, for case goods, yeah, I paid what he paid for it. Okay? It's still in the packaging. Remember, once the genie's out of the bottle, you can't get her back into the bottle. Once the fireworks are out of the case, you can't put the stuff back into the case. No different than buying bed sheets. Once you get it out of the wrapper and you get it unfolded, you're not going to fold it back into that little triangle that it came in. You got the same stuff here. Both parties told you this stuff came from China. Okay? Use your common sense, use your everyday experiences, use your life experiences. When you buy a foreign product, whether it be China, some of you have had fireworks. And he told you, it's that cheap cellophane that kind of crackles and breaks. It's also the red kind of tissue paper they put around it. And some of the stuff you've heard will fade in the sun. The exposure. It's on the shelves. It's got the dust. Okay? And he's told you that he, in his store, when the season's over, he tarps up the windows so the light doesn't come in and bleach out the product or sun fade the product. And then they would turn the product around to get the side that hasn't been exposed to the light. And the customer looks at it, oh, this looks like it's an old stuff, I'm not going to buy it. Okay? To have a contract, you need the elements. And we don't have the elements in this case here. The essential component, and that's where you, the jury, will come in and use your experiences and use what was testified to today from the box. Now let's talk about the main exhibits. Everybody's had an opportunity to look through both the black book and the white book, and the exhibits are substantially the same. Whether you look at 7 or 8, or you look at E or F, they're identical exhibits. Both parties utilize the same exhibits to bring their case. So we don't have the confusion there. The issue becomes, did he receive this product in 2002 and prior to 2003? Let's talk about that. The testimony we heard today was that they started in 2002. The selling season starts from May, it goes to July. And their first selling season was 2002. They're opening up a store. They've already got surplus stock to deliver and send away. It doesn't make any sense. You've opened up the store. What do you know what you're going to buy, what's going to be sold from what you purchased? That's a question. And we've also heard that after the 2003 selling season is when they brought in shopping carts. When Brian took the scan, he said, that's 70, maybe it was 100. Was it 200? No. Tom O'Connor said, that's about 125. I would pay wholesale price for that 125 cases because the genie is still in the bottle. She's not out of the bottle yet. But we've also seen photographs, and we've heard there's about 70 grocery carts, the big Sam's Club grocery carts that are part of Exhibit 30. And they would tell you this stuff would be taken off the shelves and put in there. Okay? They weren't concerned about inventory or bills of lading or anything to that effect because Tom was buying product from a store that was closing and he was getting it. And then when he realized what he's going to be saying, hey, this stuff isn't stuff that's going to sell, he called right away. We went through the examples of the bill of ladings, the packaging slips, the inventories, or the sales slips, the bill of ladings. Those are not contracts. Those are not legal documents other than tell you what the packaging, what's being sent to the customer from the vendor. And that's meticulously checked off. You heard both sides tell you that that's what they did. Okay? Now, this wasn't done in the middle of a sales season. This wasn't done in June or right before the 4th of July. We had to take the product from here and quickly deliver it over here. We're not going to wait for the paperwork because we've got to get it closed so it can be sold. This happened after the season was closed. The question is why was exhibits E and F, or 7 and 8, generated after the fact? We have an accountant that is sitting here checking and counting everything, putting it on spreadsheets. Where are the spreadsheets? They're not here. Okay? When we get exhibits 7 and 8 that's been generated, and we look at 7 and 8, but you mean to tell me you couldn't hold this product back for a day or two until those exhibits were done? So when it's being delivered, here's your packaging. But then when you hear both Brian and Tom testify, they told you that they would get product that would be split in this grocery cart, some would be in that grocery cart, some would be in this grocery cart. They weren't all being put together. And here's what I found interesting. When I look at Exhibit 7 and 8, or Exhibit E and F, I asked Donna, the accountant. I had 500 gram cakes, Saturday night specials, 4 to 1. We found out that means there's 4 items per container. But yet when she charges the number of cases, it's 1.3 cases. Her options are 1, 1 1/4, 1 1/2, 1 3/4, or 2. If it's 4 to 1, how do you get 1.3? So the billing is not correct. We have another example in here. 14.9. And it is world-class firecrackers in foil, 12/80/16, which we found out that the bigger the number, the smaller the product. What does the 0.9 mean? We don't know. What does the 0.3 mean? What does the 9.8 mean? What does the 3.4 mean? She couldn't tell us. She was frustrated. Okay? But if I go back to a 4 to 1, and she's putting in here 1.3 and multiplying the number, these are no good. If that's how she did this, the numbers are not correct. It doesn't come out to be whatever she said it was. Okay? So the mathematics are not correct either. You heard Tom O'Connor tell you, I purchased product from Dr. Tom DeLuzis, the surgeon, who tried to be my competitor across the street. Close shop, I bought his stuff 40 to 50 cents to the dollar. These guys told you they're no good in the retail business. They were closing shop. I thought I was buying again at a wholesale, at a rummage sale, a garage sale, a flea market. And therefore, I was going to pay what was a fair price. And in his mind, the fair price was anywhere between 40 to 50 cents to the dollar. Had he known it was $50,000, he said he would have ran. He was shocked, and he found out that number 2 years later, sitting in Don Pablo's. He paid $5,000 in 2003, paid another $5,000 in 2004, and at the meeting, he was prepared to pay another $15,000. So I think he paid a $10,000 check plus a $5,000 check, so the evidence for $15,000 for a total of $25,000. And he said this product was worth $15,000. I threw the $5,000 in there to call it quits to save the relationship. They were still balking, and I said, "Here's $5,000 more. I'm done." As far as Tom O'Connor is concerned, they've been fully paid on this case. And what we're going to ask you to do is listen to all of the instructions that the court's going to give you. You'll be given an opportunity to take both exhibits, the white and the black book, compare the exhibits. They're substantially similar to one another. And we're going to ask you to consider all the instructions that are given to you, find that there is no agreement here, find that there's no breach of contract, and find in favor of Tom O'Connor. Ladies and gentlemen, Jerry, I'd like to thank you for the 2 days you've given us. Again, this is an important case of these guys here, and we thank you for the time that you're going to put into it. Your Honor, gentlemen, thank you.
Counsel, I'll give you 2 minutes.
Thank you, Your Honor. The decision you're going to make is not an easy one. The idea is for you to take the evidence. You'll have a jury verdict. Take the evidence. Talk about it. You'll see in Exhibit F what the dollar amount is, $24,316 to the jury verdict for the plaintiff. Ask you to do that. Understand this attorney that's in this case. This is an easy decision. We ask you to enter that judgment for the change. The Walczak. That was the deal that was made. It's not right. back.
Yeah, as soon as I'm done with this, I'll tell you when. All right, ladies and gentlemen, at this time, it becomes my duty to instruct you as to the law that you will apply to the facts and issues in this case. You are the sole trier of the facts, but you are bound to apply the law as given to you by the court. When you deliberate your verdict, you will have a copy of the final instructions and all the exhibits submitted into evidence for your review. Barrett will pass out the instructions so you can read along with them. Yeah, pass them out. Everybody have a set? All right. The contract is an agreement that arises from an offer made by one person or entity and acceptance of that offer by another person or entity. Contract becomes enforceable when the parties who agree to enter into the contract exchange something of value. Something of value may include an act such as the payment of money, performance of service, or delivery of goods, or 2, a promise to act. A breach of contract occurs when a party fails to perform all the duties agreed to do, or 2, a party places himself in such a position that it is beyond his power to perform the contract. 3. To recover damages from Tom O'Connor, DBA Boomtown, USA, Tim Walczak and Andy James, DBA Planet Fireworks, must prove all the following by a greater weight of the evidence. 1. Parties entered into a contract. 2. Tim Walczak and Andy James, DBA Planet Fireworks, performed their part of the contract. 3. Tom O'Connor, DBA Boomtown, USA Fireworks, failed to perform his part of the contract. 4. Tom O'Connor, DBA USA Fireworks, breach of contract damaged Tim Walczak and Andy James, DBA Planet Fireworks. 5. Parties reasonably anticipated those damages when they entered into the contract. And 6. Tom O'Connor, DBA Boomtown, USA Fireworks, breach of contract was a responsible cause of those damages. A person's conduct is legally responsible for causing damages if 1, the damages would not have occurred without the conduct, and 2, the damages were a natural, probable, and foreseeable result of the conduct. This is called responsible cause. If you decide that Tom O'Connor, DBA Boomtown, USA Fireworks, has breached the contract, the measure of Tim Walczak and Andy James, DBA Planet Fireworks damages is the amount that would put Tim Walczak and Andy James, DBA Fireworks, in the same position they would have been had the contract been fulfilled. Tim Walczak and Andy James, DBA Planet Fireworks, may only recover the loss actually suffered and should not be placed in a better position than if Tom O'Connor, DBA Boomtown, USA Fireworks had not breached the contract. As I said in my preliminary instructions, judges and jurors perform different tasks. I instructed you on the law at the start of this trial, and I will further now instruct you as to the law. You will decide the facts of this case. Then you will decide the outcome of the case by applying all of my instructions to those facts. Do not base your verdict on sympathy, bias, or prejudice. Evidence is of the greater weight if it convinces you more strongly of its truthfulness. It is evidence that convinces you that something is more probably true than not true. A greater number of witnesses testifying to a fact on one side or a greater quantity of evidence introduced on one side does not necessarily amount to a greater weight of the evidence. Consider all my preliminary and final instructions together. Do not single out any individual sentence or point or instruction and ignore the others. The plaintiffs Tim Walczak and Andy James, DBA Planet Fireworks, sued Tom O'Connor, DBA Boomtown Fireworks, the defendant. The plaintiffs claim that the defendant breached their contract to pay an agreed upon amount of money for the fireworks that they supplied to him. Tim Walczak and Andy James, DBA Planet Fireworks, must prove their claim by a greater weight of the evidence. Tom O'Connor, DBA Boomtown USA Fireworks, denies Tim Walczak and Andy James, DBA Fireworks, claims. Tom O'Connor, DBA USA Fireworks, is not required to disprove Tim Walczak and Andy James, DBA Planet Fireworks, claims. The parties in this cause may prove a fact by one of two types of evidence: direct evidence or circumstantial evidence. Direct evidence is direct proof of a fact. Circumstantial evidence is indirect proof of a fact. For example, direct evidence that an animal ran in the snow may be testimony of someone who actually saw the animal run in the snow. On the other hand, circumstantial evidence that an animal ran in the snow might be the testimony of someone who only saw the animal tracks in the snow. It is not necessary that any fact be proved by direct evidence. You may consider both direct evidence and circumstantial evidence as proof. You alone are the judges of the evidence, including the credibility of witnesses. Credibility means believability. A credible witness is a witness whose testimony you believe. In considering the testimony of any witness, you may also take into account his or her ability and opportunity to observe what he or she testified about, the manner and conduct of the witness while testifying, any interest, bias, or prejudice the witness may have, any relationship the witness may have with other witnesses or interested parties, and the reasonableness of the witness's testimony considered in light of all the evidence you have heard. Assume that each witness has testified truthfully. If you find conflicts in the evidence, reconcile those conflicts if you can, based on the assumption that each witness has testified truthfully. Do not disregard the testimony of any witness without a reason and without careful consideration. If you find conflicting testimony that you cannot reconcile, decide what testimony you believe and what testimony you disbelieve. If you decide what or whom you believe, in deciding what or whom you should believe, you should use your own knowledge, experience, and common sense gained from day-to-day living. When you return to the jury room, select one of your members as presiding juror to manage the deliberations. No one will be allowed to hear your discussions, and no recording will be made of what you say. The bailiff is available to assist you with your personal needs, but that cannot answer any questions about the case. If you have any questions for me, you must put them in writing and give them to the bailiff, and I will respond as the law permits. You may be able to find answers to your questions by reviewing my written instructions and all the evidence. If at any time you are not all together, or if you are outside the jury room, you must not talk about the case among yourselves or anyone else. I am giving you forms of possible verdicts. The presiding juror must sign and date the verdict to which you all agree. Do not sign any verdict form from which there is not unanimous agreement. When you have agreed upon a verdict, inform the bailiff. When the parties are present, the bailiff will bring you to the courtroom, bring all the verdict forms, signed and unsigned, with you at that time. I will read the verdict aloud. Each of you may be asked if it is your verdict. Otherwise, you are under no obligation to discuss your verdict or deliberations with anyone. All right, ladies and gentlemen.
Your Honor.
Your Honor,
Yes.
May we approach?
may we